Hello and welcome to Between Parks Place and Capitol Hill, Six News' program all about law and government in Australia, and in this case, also in the world. I'm your host, Stuart Jeffrey, GovCheck editor here at Six News, and with me today is Elijah Granner, our international correspondent. And joining us today is Professor Gabriel Appleby, a professor, I believe, at University of New South Wales, and the author of our paper that we're discussing today on federalism in the US, Australia, and Canada, and also about integrity for judges and things like that, which I think will be a very interesting topic. This will be a bit of a longer show. We're going for the full hour this time. I just think we need that to try and really get into the issues that we have here. And so my first question for you, Gabriel, is just this introduction to comparative law. How do we do comparative law? How do academics and judges go about comparing law between two systems?
Yeah, thanks, Stuart. And it's a real pleasure to be here. I'm really excited to be talking about this topic with you both. The question of how do judges and scholars go about comparing legal systems, I think, is actually preceded by a question about why would you compare? Like, what's the purpose of comparing legal systems? And that kind of leads you to an answer about how you do comparison. And people do comparison of legal systems for lots of different reasons. Sometimes they do it because they want to better understand what's going on in their own legal system, and looking at how other legal systems are operating gives you a better understanding of your particular context and features, and so you have a better understanding of what's going on in your own legal system. Sometimes it's because you've got a difficult, complex problem, political problem, legal problem that your system's throwing up, and so you might want to look and compare with other legal systems that are grappling with similar problems but might have a different approach to resolving them, and seeing whether there are things that can be learned, or what we call sort of lessons from comparisons. And you'll see that in scholarship by academics, but you might also see that in judicial decision making, where they're looking at a particular legal issue that comes before them in the Australian context, and they're trying to resolve it, and they're looking, well, how is this resolved in other systems? Do they have similar features or different features? Is that resolution the appropriate one in our system? And then some people use comparison to draw sort of more general, large theories, sort of global pan theories about legal systems, about political systems, about their design, about their operation. So you can use comparison for all different reasons. And then the question of, well, how do you do comparison? Well, if you're sort of trying to draw big general theories, you might want to look at as many countries as you can with lots of different contextual factors, political, historical, economic factors, so that you can draw more general theories. But if you're looking at it for the specific purpose of trying to work out lessons from one system to another, you actually want to probably reduce those number of comparative jurisdictions, go really deep into them, understand what's been driving a particular way in which a legal system's operating, what is the specific legal, political, historical, social, economic context, so you can see whether those lessons would actually transpose into another legal system. So you have, big comparisons, and then you have what we call small n, or, small number comparisons as well, which are much deeper and much more contextualized.
I think when we look at these kind of small n comparisons, there's two documents that come up that are obviously very influential leading into Australian Federation. That is the US Constitution and the British North America Act of 1867. And these are sort of the two documents that we know were sort of very widely read, had very different influences, but equally reflect two systems that are in their own way quite different to Australia, of the American Constitution and the Canadian one. So when we look at this kind of trio, the big three of federal democracies in the rich Western world, how do we go about comparing them, and how do we both find the things that are in common without committing the easy mistake of going, oh, both countries have a House of Representatives and a Senate, we can assume they're all the same?
Yeah, I mean, I think the answer that I always give to my students and to myself and remind myself often is slow down, ask questions, and ask someone in the jurisdiction, right? Because I think a lot of this, you can look at the history, you can look at the constitutional documents, you can even look and read about practice. But I think unless you're talking to someone to understand the context behind why it's actually happening that way, and really slowing down and reading that context, you are likely to jump to conclusions of, oh, this looks the same, this looks the same. We're looking at a similar context here, and we can draw conclusions. Because if you actually speak to someone in that jurisdiction, they might say, well, actually, no, it operates that way, not because of the constitutional provision necessarily, which might look the same as the Australian provision, but because of this practice that developed over a number of decades because of the particular power of a number of states during that time. You know, so having those conversations is invaluable. And one of the things that in relation to the article we're going to discuss today, I've co-authored it with my wonderful colleague and friend, Professor Erin Delaney from Northwestern University. And she has expertise in the US and Canadian federalism. And so we were able to draw upon each other's deeper knowledge, as well as draw upon our networks. You know, a piece like this isn't something that you write alone in your office and then put out into the world. You ask others to read it who have that deeper contextual understanding. That's how you don't fall into the mistake. It's a slower process, but I think it's well worthwhile.
That absolutely makes sense. And I mean, there are so many examples of it. Famously with Canada, for instance, if you had just read the Constitution, you would not know that the office of Prime Minister of Canada exists, nor a cabinet, nor anything other than a Privy Council, which would not give you any hints as to the actual shape of Canadian federal government. And so it is absolutely kind of invaluable to look at those common points. And I think that leads into, how do we find things that we can measure and see between those countries? And the one that your article looks at that I'm a bit scared to say is autochthony, if I've said that right. And so can you go over kind of what that is and why that's an interesting dimension, especially in the judicial autochthony, to look at usefully between these three countries?
Yeah, absolutely. So autochthony is a word that Australian constitutional scholars are probably more familiar with than scholars in America or Canada. Autochthony refers to the responsiveness, representativeness, and accountability of the judiciary to the local community that it's serving, right? So when we're talking about courts and judiciaries and the legitimacy of those institutions, that is the extent to which people accept that their decisions need to be enforced and complied with even when they don't agree with those decisions, we often think about what we sort of refer to in the paper as integrity values. And these are well known across the world. Values like judicial independence and impartiality, equality of the application of the law, consistency and predictability. So sort of rule of law type values. And everyone would sort of agree. They may not agree exactly how it's instantiated, but everyone would agree, oh yeah, you need to have judicial integrity to have this legitimacy of the courts. But what we're saying is that in federal systems, right, in federal systems where you have already agreed at the sort of at the core is that there will be an element of localized, region or state or provincial, whatever name you give that subnational grouping, there will be an element of regional autonomy, right? And that's important to preserve that regional identity, whether it be because of diversity, ethnic diversity, language diversity, historical diversity, geographic diversity. But people also want to see a central national identity developed as well. So there's like two identities going on. There's the regional identity and there's the national identity as well. So there's a sort of common sense, yes, we want to come together as a nation, but we want to keep quite a firm commitment to regional autonomy as well. So if you think about that from the judicial sphere, there is also a sense that courts, when you go to court and have your disputes resolved, whether it be disputes with the government or disputes with your neighbour resolved, those courts are also reflective of both that national but also that regional autonomy. So we talk about judicial autonomy as the representative, accountable dimension of the judiciary to the particular local society that it serves. It needs to be locally representative. People need to be able to see that this isn't just coming from sort of the capital to them. It's locally representative, it's locally responsive. We see that, for example, in Australia, we have a number of the states' court systems have developed systems for Aboriginal offenders in relation to the particular local communities, saying, well, look, we want a court system that's much more responsive to what's culturally appropriate and needed within our communities. So it's responsive to what's to the local communities, and there's a flexibility that allows them to respond to local problems. So that's autochthony, judicial autochthony. And we say that when you're talking about legitimacy of courts, it's not just the integrity values that are important. It's also these local autochthony values that are important, and you've got to work out how to get that balance right when you're designing a court system.
I'm curious how this relates to the point of the actual division of powers between the federation and the states or provinces. Obviously, in Canada, you have the criminal law being an exclusively federal power, and in the United States, you have completely overlapping and parallel federal criminal powers. And there are all sorts of it. And then in the Australian Constitution, the courts have to figure out later which ones are inherently exclusive powers and which ones can be shared. And I'm curious, do those things necessarily determine the way the courts are allocated, or is that almost parallel to the court design? How separate can this judicial autochthony be from the rest of federalism?
I think you can't separate them. But I think that's the case in relation to all dimensions of federal design. And what's really fascinating is that comparative federalism is something that, you know, has been of interest to scholars and commentators for decades, if not centuries. You know, in fact, the drafting of the Australian Constitution is this wonderful exercise in many respects of comparative federalism, where they're looking at not just the United States Constitution and the Canadian Confederation, but they're also looking at sort of, you know, what's happening in Switzerland as well. And so, you know, comparative federalism has been around, being practiced, being commentated on for a very long time, and is very rich. And within that, things like the division of legislative responsibility, which you just referred to, how the executives between the subnational and the national level interrelate, and of course, how money is raised, and who has the responsibility for raising money, spending money, and how it flows across the federation, what we call fiscal federalism, are all areas of significant research. And within those areas, everyone accepts that there is this interconnectedness between them, you know, talking about legislative division of powers and who's responsible for what, whether it's exclusive or concurrent, is intimately connected to money. And things like imbalances in terms of how much responsibility you have for particular administrative areas versus how much money you have and authority to raise is an example of that interconnectedness. So we absolutely say how you design your federal court system is going to be connected to these other aspects of federalism. And in many moments, in many cases, and we look particularly, as you say, at the Australian, US and Canadian instance, these questions of designing the court system at the founding moment of federation become so entwined with these struggles over whether the centre is going to get more autonomy or what level of autonomy is going to be left to the subnational units, and concerns about over-centralisation by the subnational units, not just through legislative division of power, not just through fiscal responsibility, but through the courts. There's a real concern that a single national, what we call a unified court system or integrated court system, would wrest more control away from the subnational units to the centre. This is all part of that general struggle that happens at the founding moments of federations. And what's, of course, really interesting is our historical sort of studies show that very often these are such curly issues, such difficult issues for the founding. I'm going to say fathers because in both instances it was men. Of course, women are becoming involved in less formal capacities and subsequently. They didn't deal with this. And in fact, the compromise was just to leave it to later, right? To sort of keep the current system that was operating previously and actually work out how much becomes integrated and how much stays as state and national to a later time. And we see that both in relation to the Australian and the United States constitutions. And so then it has to be the legislatures and the courts grappling with questions of integrity and autonomy later in the operation of the federation.
Now, long-time readers of the Commonwealth Knowledge series that I do here on Six every weekend will know that the way that the federalism works in Australia is that the Commonwealth government has enumerated powers mostly found in Section 51, but of course there are some other ways to get around it in the Constitution, and it's the same in the US. But in Canada, as Elijah alluded to, it's a different system. You've got complete control of the criminal system at a federal level and kind of an inverse federalism where the national government has a lot more power than the provinces and the territories do. How would that affect comparisons between Australia and the US as it's Australia and Canada, that division of power in the legislature?
Yeah, I mean, I think it just it raises it not concerns the wrong issues. It indicates that care must be taken in relation to drawing quick, perhaps, and too easy conclusions. But what is really fascinating and perhaps a greater point of distinction between the US, Australia, and the Canadian experience is, in fact, the particularly unique position of Quebec in the Canadian Federation, both at founding and continuing, and through subsequent constitutional negotiations. And of course, that's a colonial artifact. It's an ongoing cultural, linguistic, religious distinction, and there is enormous political power in one of the provinces in terms of the autonomy and autochthony and the political negotiations, and an ongoing concern by one province within the federation that there has been an insufficient level of autonomy given to the provinces. So this kind of different political dynamic is actually, I think, more relevant to keep in mind and be alive to and concerned about if you're trying to draw comparisons across jurisdictions in the Canadian context, because this is what's really driven the ongoing concern with insufficient regional representation on the Canadian courts. The points you make around greater federal control over matters such as the criminal jurisdiction has led to a more integrated court system. But what you've got is this ongoing advocacy by Quebec for greater regional control. And that's not just about courts. That's the other point, coming back to Elijah's point. It's actually about the whole federal compact, and courts are part of it. But they actually want to reopen the whole federal compact in relation to levels of autonomy, and courts become one part of that.
And I think one interesting point is how granular that Canadian compact can restrict that autochthony. So the 1867 Constitution Act 1867 is now called requires that judgments in Quebec be in English and French, which at the time was a sort of very colonial deigning gesture to say, no, don't worry, we'll have them in French too. And of course, now is a sticking point in Quebec where they are quite annoyed that their judges have to speak English as well as French. And so it's interesting how these things can go over time. And I think that brings us to the question of legitimacy and what it means to walk into a court. So in the United States, you'll walk into a state court and there will be the state seal on the wall and it will enforce state law, and the judges will be appointed or elected by the people in that state. In Australia, you'll walk into a state court and the state coat of arms will be on the wall and the judges will be appointed by that state, but it will also be enforcing federal law. And then in Canada, you'll also walk into a provincial superior court. It will have the provincial coat of arms at the wall, but the judges will be federally appointed and enforcing both. So how does that mix in each case when the person walks into their court? How does that change how they see the legitimacy? And I think one interesting point is how granular that Canadian compact can restrict that autochthony. So the 1867 Constitution Act 1867 is now called, requires that judgments in Quebec be in English and French, which at the time was a sort of very colonial deigning gesture to say, no, don't worry, we'll have them in French too. And of course, now is a sticking point in Quebec where they are quite annoyed that their judges have to speak English as well as French. And so it's interesting how these things can go over time. And I think that brings us to the question of legitimacy and what it means to walk into a court. So in the United States, you'll walk into a state court and there will be the state seal on the wall and it will enforce state law, and the judges will be appointed or elected by the people in that state. In Australia, you'll walk into a state court and the state coat of arms will be on the wall and the judges will be appointed by that state, but it will also be enforcing federal law. And then in Canada, you'll also walk into a provincial superior court. It will have the provincial coat of arms at the wall, but the judges will be federally appointed and enforcing both. So how does that mix in each case when the person walks into their court? How does that change how they see the legitimacy of the court that they've just entered?
Yeah, I mean, what a great way of summarising some of the key differences and the different points along the spectrum that the different jurisdictions sit in terms of dual and integrated. Look, I think it goes even further back to when you walk into the courtroom, though, as well. It's a question of where do you file your case as well in some jurisdictions, because of course in Australia you may have chosen to file your case in the state court and have it determined by a judge appointed by the states, but who may be applying federal law. Or you could have chosen to commence that in the federal court, where you've got federal coat of arms and federally appointed judges. So there's actually a whole, it goes even to the further back. Look, I think that this is something that we really try to unpack in the article. In many instances, you would have very little concern in relation to the level and quality of justice that might be being dispensed, and that there's generally a sense that whether you're in a state or a federal court, you are getting a high level of integrity. Now, that may, in the US and in Australia, where you have the state courts potentially applying federal law, less so in the US now because of the way in which the jurisdiction has been tweaked, you may have some concerns that, the state procedure, the state judicial appointment method, the state remuneration method for judges, it differs from the federal level. Maybe there's some concerns around quality of justice that's being dispensed. Now, the Australian High Court has tried to remedy that and require kind of minimum standards across both state and federal courts. So that's kind of trying to allay the concerns of the litigant, the parties, that if they go into a state court applying federal law, they're going to get the same, what the High Court judges refer to as grade of justice, the same quality of justice, regardless of which jurisdiction they're walking into. But the Canadian problem might be a bit different, right? So rather than being concerned about the quality of justice that you're going to get in terms of integrity values, you might be concerned about the quality of justice in terms of local understanding and responsiveness, because you've got a judge appointed from Ottawa and you're a long way from Ottawa in a regional area, and you think this judge is not going to understand what my concerns are. And so you may have autochthony concerns that arise because of the way in which that particular judicial system is structured. Now, how you go about managing those concerns is all about that design of federal systems.
I want to get a bit more into that sort of discussion about integrity and legitimacy, but before we get into that, is there a difference between those two words? What does integrity mean versus legitimacy in the judicial in this context here? If we're talking about the courts rather than government as a whole, is there a difference, or are they interchangeable?
So legitimacy is a bigger term. It's a broader term. It's about the level of respect that's accorded to the court and the decisions that the judges are making, the extent to which, people within society and governments, of course, as well, being an important player in society, accept that judicial decisions must be complied with, judicial decisions must be enforced, they can't be ignored, even if they're not the decision you want, right? So even if you disagree with the decision, the government still sends in the sheriff if needed to enforce the decision, right? Or complies with the decision if it goes against them. And that's the concept of legitimacy, that sort of social legitimacy of the courts. Now, integrity goes to legitimacy, right? An independent judicial system, one in which society perceives that there is consistent, predictable decisions being made. There's an equal application of law, whether it be to government or to an individual citizen. These kind of rule of law kind of principles help foster judicial legitimacy and people's acceptance that the judges have this legitimacy. But what we say in our article is that in federal systems, there is another input. There is another input into legitimacy, which is autochthony, which is local representative and responsiveness of the courts. And to take the example that I referred to earlier, so in Australia, where you have a number of states and territories introducing Indigenous courts, particularly around sentencing, you have a system of courts that wasn't working for the particular local Indigenous communities. And so they've responded by having a much more culturally appropriate system of courts. And from all the research that's been done and the outcomes, they're getting a much better outcome in terms of those court decisions being complied with by individuals and having the effects that's wanted for those individuals and the outcome that's wanted. So local autochthony is also part of legitimacy, but it's another input. So integrity is part of legitimacy, and we're also saying that local autochthony is as well, judicial autochthony.
And to what extent does this come into judges' thinking as they figure out where these kind of boundaries are? And that can be things like discussed in the article with the U.S. Supreme Court looking at review of state courts and balancing the legitimacy of constitutional rights against the autochthony of state courts to, I think, what we've alluded to before, the cable doctrine, the idea that of these like meat, there's a minimum grade before you can offer it to the public of justice. How does these concerns sit with what might be thought of sort of as black letter legal reasoning? We have the Constitution, we can just figure out what it is by logic.
If you continue to subscribe to that view, and I would say it's an increasingly less subscribed to view, particularly in areas of constitutional law. So you see this feature heavily You see the judges in the US and Australia in particular, because they're the two case studies in which we have management of that tension between, or the balance between, integrity and autonomy arising through implications. In the United States, the Supreme Court is using the due process clause, so individual rights clauses, and extending it to the states and saying, well, in individual cases coming before the courts, they need to meet due process requirements and importing ideas around fair trial, independence, impartiality, right? So introducing integrity values into the state level courts through a rights-based provisions, case-by-case, individual-based implication. And in Australia, which one of the key distinctions at a constitutional level is we don't have a Bill of Rights. We have a smattering of rights in our constitution, but we don't have anything like the due process clause. The High Court has, however, implied from the guarantees of judicial independence and the separation of judicial power for federal courts, an implication that state courts, which can also exercise federal judicial power, must also meet the minimum requirements of independence and impartiality, right? So this is a judicial implication as well. It's not a rights-based implication, it's a sort of structural-based implication. In those cases, we see judges openly grappling with this value tension. So under the Cable Doctrine, which is the case in which this structural implication was first found in Australia, you see judges discussing the importance of state courts being able to continue to experiment and respond to local situations, state legislatures being able to create new schemes which use state courts, you know, in not necessarily traditional ways, but are trying to respond to local issues. And that's not necessarily seen as impeding on judicial integrity, but then they say, but there also has to be this minimum. You can't introduce a scheme that would require the states to act at the dictate of the government, or you can't introduce a scheme whereby, for example, you would have a whole set of state courts that's only short-term acting judicial appointments. That would undermine judicial integrity. But a system which has some acting judicial appointments to fill in some gaps as required, you know, the High Court's not going to interrupt that kind of scheme. So this tension between the autonomy values, the federalism sort of local values, and the nationalising integrity values is very openly referred to in these judgments. Yes, they are doctrinal judgments, they're about an implication, but the implication is balancing these bigger values, these federalism values in the judicial context.
I think one of the really interesting things discussed in the article is the point that the Australian system has a quirk the US and Canadian don't, which is the US has separation of powers and Canada has the Charter of Rights, whereas in the Australian context, there's this judicial awareness that a state could, if it wanted, have passed a law that simply said, instead of the judge must send Mr. Cable to prison, the law could just say Mr. Cable is in prison. There's no bypassing the judiciary. And I'm curious about how that political awareness plays on how bold the judges are willing to be in defending the integrity and legitimacy of the system.
Yeah, what a great question. And you see this concern in the judgments themselves. And I think the former Chief Justice of the High Court, Murray Gleeson, in a number of his judgments, really grapples quite openly with this. And, you know, his concern is if the High Court were to be too heavy-handed with this implication and to strike down some of these state schemes, this is particularly in a context where the state legislatures were experimenting with schemes around control orders, continuing detention orders for individuals who are involved in organised crime, and getting the courts involved in the making of those orders with pretty limited, sometimes no discretion and involved. You see the courts, and in Gleeson's judgment in particular, his judgments in particular, he openly talks about, well, if we say that they can't do this with the courts, they could take this power away from the courts and they could give it to a panel of psychiatrists, or they could give it to themselves, executive officers, the Governor General. And that would be a bad outcome, because courts bring with them all of these safeguards, even if they are, in particular circumstances, more limited safeguards. They are a better vehicle through which individual rights and fair process rights are protected. And I think that kind of political awareness, that if you make it too hard for state parliaments to use courts in schemes like this, anti-organised crime schemes around sexual offenders, then the imperative for states to act in these very kind of political crunchy areas, law and order areas, means they're going to still act, but they might just write the courts out of the game, and that would be a bad outcome. Now, there are other judges on the High Court who disagree, right, who say, well, no, we have to protect the integrity of the courts at all costs. And, death by 1,000 cuts means that you're actually going to undermine the courts to such a degree that you don't even have those benefits of using the courts, right? So there is not a uniform position on this at the judicial level. And other judges aren't engaging in this political conversation at all. They're just dealing with the implication and the doctrine in front of them, okay? But you do see it in some of the judgments, this real awareness. What's really interesting is that we haven't, with just one or two exceptions, we haven't seen the Australian state parliaments move away from using the courts in relation to these schemes. Whether that's because the High Court has kind of got the balance right, you have to have minimum integrity levels, but you can still do some experimentation and use of the courts in these schemes in some way, or whether that's just because, like, politically it would be really unpalatable to deal the courts out of the game. Like, it's actually hard to sell a scheme in which people are subject to ongoing detention or liberty restrictions where the judges don't get to review that. So, the politics of it has meant that they haven't shifted away from the courts, but the courts are aware that they might.
Now, of course, the basis in Cable for that was that although we don't have separation of powers at a state level, only at a federal level, whereas the US has separation of powers at both levels, was that the Supreme Courts of each state have federal jurisdiction, and therefore Chapter 3 of the Constitution, which implies that separation of powers for the judiciary, also affects state courts who have that federal power. But of course, this brings us back to something that you raised in the article, which is that at Federation, we only had a High Court. The federal courts were created at a different point in time. Before the federal courts, you had the High Courts, and then you had the Supreme Courts at a state level. There was no other federal courts. So how does the creation of the federal courts affect the Australian model? I know you mentioned in the article talking about a hybrid system or an integrated system or a dual system. How does the existence of the federal courts change things for Australia? Because I know that was brought in, I believe it could be the 70s, if I'm getting that right. So how did that affect things when we're talking about an integrated system and integrity?
Yeah, I mean, so Australia had a largely dual system where we had the continuing state courts, which were the previous colonial courts, the Supreme Courts, and the courts that sit below that, usually called the district or magistrates or the district or local courts. They continued, and Sir Owen Dixon very famously referred to as the autochthonous expedient. So that's why Australian constitutional lawyers know the word autochthony. This was part of the founding compromise, whereby the idea of creating a whole new system of federal courts at the moment of federation was just too economically difficult to contemplate and logistically difficult to contemplate, right? They were going to have to spin up a whole new public service. They were going to have to spin up a whole new legislature. They just didn't have the time and resources to also spin up a whole new set of courts. They were going to have to spin up an apex court, the High Court of Australia, to sit atop and to be the final arbiter. And they did that a couple of years later in 1903. But they just continued to use the state courts, appointed by state judges, as Elijah said, and operating in accordance with state procedures as well for decades. Now, there were concerns that were developing, not so much integrity concerns, but concerns around consistency about application of federal statutes across the federation that drove the introduction of the federal court in the 1970s. But the federal court is a court of relatively limited jurisdiction, right? It's not the court that has exclusive or federal jurisdiction, and generally tends to operate in particular specialist areas, right? So immigration being one of them, family law being another. There's a specialist family court, although the Federal Circuit Court exercises family law jurisdiction. The sort of copyright, trademarks, this kind of area. So the federal court has still got specialisations, and the Supreme Courts of the states still have a general federal jurisdiction. So if you have a federal claim now, you can usually choose whether to bring that in the state courts or in the federal court, right? So we actually now have this kind of choice of forum question that's arising. Would you prefer to go with the federal court or with the state court? And that brings a whole lot of questions around, is there really no two grades of justice in Australia? Or do we have a bit of forum shopping there, whether that's around integrity or for reasons around specialisation, etc. So it absolutely feeds into this conversation and is a complicating dimension of it. What has been interesting is the continuation of the state court's jurisdiction over federal matters even after the creation of the federal courts, and that the federal courts have not taken that exclusive responsibility over federal jurisdiction.
I'm really glad you said family jurisdiction then, because that's one of the big questions I had for you, is that of course, Section 51 does not include any family court powers. That was based on the referral power. And every state except Western Australia referred that power to create the family court. So Western Australia has its own family court. How does that affect things when it comes to an integrated system, having one state with its own family court rules and everyone else relies on the federal court for family court matters? How does that affect things?
Yeah, it's an interesting dynamic. It's sort of you might see some similarities with the sort of dynamic in Quebec and Canada, and one province doing its own thing, one state doing its own thing. Of course, Western Australia has always had a tense relationship with the Federation, from pre-Federation to post-Federation, and the extent to which it wants to be fully involved, or whether it wants out completely, of course, which it voted for in the 1930s. So it's a sort of a point where you see the value of autochthony for one particular state as seen as extremely important, and that's probably for political reasons as well as legal reasons, to the extent that it actually sort of impacts on the operation of the Federation. Now, I'm from the eastern states, right? I grew up in Queensland and I practiced in New South Wales and South Australia and worked there. So, the fact that Western Australia has its own family court, family law system and family court system hasn't always sort of been an anomaly. It's there, you have to acknowledge it. But I think if you're in West Australia, it will be a really important part of your regional identity. And the question of whether it should be referred now, given it's been operating for so long, would be a really big question about regional autonomy, and is it appropriate for that dictate to be coming from the national. So I think you'd see that tension between that sort of centralisation and autochthony really play out if you tried to change that now.
And then to move to something you've mentioned a couple of times, with the states experimenting with courts to deal with the unique circumstances of Aboriginal or Torres Strait Islander offenders. One of the interesting things about the United States, for all the many terrible, terrible things it's done to the indigenous inhabitants, there is judicial autonomy for tribes. They have their own court system. They can pass their own laws. If you are a tribal offender, you can and indeed must be tried in a tribal court for an offense committed on tribal land. That is something that Canada and Australia lack. And I'm curious, in a time where we are all rightly talking about indigenous autonomy, and of course that's something you've worked on and advised on, to what extent is judicial autonomy part of the growing consciousness of the need for institutions that represent indigenous people across these three countries?
Yeah, this question is very much a live question in Australia and has actually a number of different dimensions to it. I just want to take a step back before we take a step forward as well. And there are constitutional systems in which the constitutionalized federal judicial design, as opposed to the agreed operation of things like the tribal judicial systems on tribal lands in America, incorporate tribal courts. So, for example, the South African system or the Malaysian system actually has, within the federal judicial design, explicit jurisdiction given to tribal and indigenous courts. So it's something that can be dealt with at a constitutional level as well. The systems we're looking at don't, and so we have to work out, well, how within the constitutional system of judicial design do we accommodate appropriately and balance questions around integrity and expectations of integrity with autochthony, which have this additional dimension when we're talking about First Nations and Indigenous peoples. So just to make that point initially, so in Australia, we, of course, we have a very different history in relation to colonisation and relationship with Indigenous peoples. There are similarities, of course, in terms of colonisation predominantly by the British and the dispossession and violence that followed. But in Australia, we don't have a founding agreement, treaty or treaties with the different Indigenous nations, from which these negotiations can kind of draw their foundations, and from which sort of modern acceptance of levels of autonomy for Indigenous peoples, whether it be on their lands or otherwise, sort of has a foundational basis, even if it's not constitutionally textualised basis. There's a constitutional foundational basis for that. So in Australia, we're coming from this different starting point. It is different. I'm not going to say harder, because I know that there are so many challenges across all the jurisdictions, but it means that ideas around autonomy in relation to the even the existence of Indigenous laws, let alone their application within Indigenous courts, is a much more difficult question. We are seeing, and we have seen for decades and centuries, arguments in relation to the application of Indigenous laws, particularly in relation to disputes between Indigenous peoples, and whether that's the most appropriate resolution for that, whether Indigenous customary penalties and sort of sentencing or other penalties are more appropriate, and the extent to which the circumstances of Indigenous offenders can be taken into account if they are sentenced or punished in a state level court. So there's a whole lot of dimensions that are happening in Australia. Where we've got to is a situation where in a number of the states and territories we have Indigenous sentencing courts, which usually they operate in different ways across the different states, because you've got experimentation and local responsiveness, because of course in the Australian for Australian Indigenous peoples, there is not a pan-Indigenous culture or identity. They're very different across the country, as is the case, of course, in the United States and Canada. But generally these courts are operating in a way whereby local elders are sitting with the judicial officers. They're providing a much more culturally safe environment in which the Indigenous offender can talk about the circumstances which led to the offending. That sort of cultural knowledge can be imparted to the judicial officer, and a more culturally appropriate response to the nature and type and circumstances of the offending can be developed, and then the Indigenous community can be involved in sort of whether it be the community rehabilitation in implementing that. In addition to that, there is now a decision of the High Court that says when you're sentencing an Indigenous offender outside of the context of those Indigenous courts, the complete individual circumstances of the offender need to be taken into account, and where that offender is an Indigenous offender, that will include things like the intergenerational trauma of colonisation and violence and how that's impacted on them. So we're at quite a different position in Australia, but it is something that remains an ongoing conversation, and we are seeing the increased use of these Indigenous courts in New South Wales, where I'm currently living. We've just seen the expansion of those courts out into the regions, and I think that's a really positive development. There's still a long way to go. For example, not just in criminal matters, but in child protection, removal of children matters. There's really great concern that there's not enough Indigenous input and localised, understanding of what's actually happening by the government and by the courts in their decision making.
I think probably the final issue, I'm just looking at the clock right now, probably the final issue I want to cover. I would love to keep going past the hour mark, but unfortunately my boss says no. So if you want to blame anyone, blame him. It's not my call. Blame Leo. Probably the couple of questions I have for you is turning a little bit, like we were talking a lot about Australia here, but going back to the US as well, appointment versus election of judges. How would that affect integrity? Of course, we've all seen every few years when a US judge retires or more likely dies while they're on the Supreme Court, there's always Senate hearings about appointing a new judge, or in fact, at a local level, often judges are elected, although that varies from state to state, whereas all of ours are appointed in practice by the Attorney General and the Premier or the Prime Minister, but in theory by the Governor or Governor General. How does that affect questions of integrity and legitimacy, knowing that there's different forms of accountability there for judges? How does that play into things?
Yeah, it's a really interesting question because, of course, contemporary modern conversations about this are usually filled with great concern about the diversity of the appointments systems that operate across the United States at the state level. And they range from executive appointment with legislative confirmation, like we see at the Supreme Court level, but that can happen at the state level as well. Legislative appointment all the way through to partisan, non-partisan elections, and then kind of like hybrids where there's appointment by a commission that might then have like a retention election after that. So there's this whole range of ways in which judges are appointed in the US, and people have sort of really zeroed in on the election of state court judges as a real concern for integrity, that perhaps the problem that autochthony has run away with itself here, and that the Supreme Court should really be imposing integrity standards in relation to judicial appointments processes, that elections are raising serious concerns, particularly with large donations that might be received, and about the impartiality of those judges who are elected. But of course, what needs to be remembered in the US context is that the states, when they introduced these schemes, and particularly the election scheme, were actually themselves responding to integrity concerns, right? So the election schemes that we introduced in the United States at the state level were responses to concerns that executive appointment of judges was leading to overly partisan and corrupt judges. And so the introduction of elections in the United States at the state level was initially seen as a really important, innovative local response to integrity concerns. And this is one of the important things about judicial federalism. It's not set and forget, right? It can't be set and forget, because politics changes, and the legal systems needs to be able to evolve to those sorts of changes. And so now we have a different set of integrity concerns, and it's played out in a number of cases. These aren't just hypothetical abstract concerns, but What we see at the moment is that the Supreme Court unwilling to use this implied doctrine based on rights to get at questions of appointment. And so we see so far them not sort of enforcing minimum integrity levels there. But it is about like continuing to watch the calibration. Is the calibration between integrity and autochthony right? What might have been right 50 years ago may not be right for the politics of the day.
And it's a longer interview than usual, but we really appreciate you joining us for our introduction to comparative law.
It's been a real pleasure. Thanks for the conversation and the interest.